Thank you, FACCNE, for hosting us today. My name is Danny Mayer. I'm an attorney at Fragomen, and I'm on the board of directors at FACCNE. I'm here today with two of my colleagues from the Fragomen Boston office. We're a law firm that's focused on business immigration, and we're here to talk about U.S. immigration updates. This session will be recorded. If you'd like to refer to it in the future, it'll be on the FACCNE website. And now I'll introduce you to my colleagues. Aaron, a partner here in Boston, and Brian, a senior associate, and I'll pass it off to Aaron to begin our presentation.
Great, thanks Danny, and hi everybody, welcome, thanks for joining us today. So I want to get started with a couple questions, and the way we're going to do it today is we're going to have a little panel with Danny and Brian, and I'm going to be asking them a few different questions as we go through different scenarios that you all may be encountering navigating this immigration system. So generally speaking, we tend to see two types of clients seeking our assistance. Companies who are established abroad that are opening an office in the US and need to hire foreign nationals, and then companies with no presence abroad, but who have opened up a US office and are in need of support in hiring foreign nationals to work in the US. So I want to turn this one over to Brian. If you could kind of walk us through the various visa options available in each of these two scenarios, that would be a great way to kick things off.
Absolutely. Thanks, Aaron, and thanks, Danny, for having me here to chat. So there's really going to be some sort of most common visa types that we're going to see, depending on what a business's needs are, depending on where their foreign national population is, where they're hiring from in the world, whether it's inside the United States, outside the United States. So I'm just going to run through some of the more common options depending on those scenarios. And really sort of the most common sort of US work visa option that we see out there is the H-1B visa type. So the H-1B visa type is for what's called a specialty occupation for a professional. And it is a category that comes up fairly often. It tends to be what individuals in the US in a work authorized capacity most commonly hold for a visa type. But a few key things to understand about it. Number one, in terms of a hiring perspective, most commonly going to be used when a business is looking to hire, not required, but most commonly used when a business is hiring individuals already present in the United States, whether they already hold H-1B status or, for example, if they are here on a student visa studying at a university in the United States and they're sort of heading out into the professional world, sort of at entry-level roles. So this is commonly seen in sort of a transition from students into the H-1B visa type, or for employers, looking for a lateral transfer to their company in the United States. Now, the H-1B visa type sort of has two key elements. Number one, that the position that a business is hiring for is one that typically requires a bachelor's degree. That's sort of what we consider to be a professional position. Then that the candidate that you're hiring has a degree that aligns with that role. So a common sort of exaggerated example is, a software engineer role might meet the H-1B requirements, but an individual who has, a degree in English is not going to be one that sort of meets the H-1B requirements because their degree is not aligned with what the role is. One really tricky aspect of the H-1B visa type is that there is a limit or a cap annually on how many H-1B sort of visas are given out to foreign nationals. It's capped at 65,000 with an additional 20,000 slots for individuals that hold US master's degrees. So it is one that you essentially enter a lottery every spring. Employers can sponsor foreign nationals to enter the lottery, but it can be very tricky and can be hard to plan because right now, the selection rate in the lottery, we see about almost 500,000 registrants in the lottery each year. They only have a set number of slots, and we see that the selection rate is about 25%. So, as of this past year, you have a 1 in 4 chance of even being able to get the H-1B visa type, even if all the eligibility requirements are there. So that's sort of the first thing, it is a very common visa type. It's sort of an entry or sort of gateway visa type to permanent resident status in the future. And many individuals sort of aspire to hold H-1B status because it offers a lot of flexibility on that front. One other thing, and Danny, if we can move to the next slide. One other thing that's important in terms of being able to move forward with permanent resident status in the United States is that the H-1B visa type is what we call dual intent. So not every US visa type allows someone to have the intent to get permanent resident status, the intent to get their green card while holding that status or while entering the United States or gaining that status in the United States. But the H-1B visa type is one that allows one to have either temporary, what we call non-immigrant intent, or permanent resident, or what we call immigrant intent in the United States. So it is also a very flexible visa type on that front, and is a good visa type for individuals to eventually transition to permanent resident status in the United States as well. A big component also in hiring anyone in the foreign national population is, well, what does it mean for my family? What does it mean for my spouse? My spouse needs to be able to work. So there is work authorization available to spouses of H-1B visa holders who have reached a certain sort of part of the permanent resident process. So it's not guaranteed. It's not something that a spouse of an H-1B visa holder is going to get right from the get-go, but there is a rule in place that allows, essentially spouses of H-1B visa holders to eventually get work authorization, but certainly something to keep in mind in hiring, because it is a common question. My spouse needs to work. Is this going to be something that's feasible? And it may not be right from the start eventually, but not right from the start. So that's sort of the H-1B visa type. And again, you could hire someone from outside the United States and they can obtain H-1B visa status and they could go through this annual lottery. But the more common method of bringing in talent or bringing in individuals from outside the United States is going to be the L1 intercompany transferee visa type. So this is, the prime example. You have a business in France and you've opened an office in Boston in the United States, and you need to staff that office. And you have all the talent that has the knowledge or sort of has been working in a managerial capacity for the organization in France. So the L1 visa type allows you to transfer individuals to the United States who have worked for an affiliated or a subsidiary entity of the same organization outside the United States for at least 1 year. So there are two types of L1 visas. There's for executives and managers, and there's also specialized knowledge workers as well. So there's two different types depending on what the role has been for the organization outside the United States and sort of what their role will be for the organization inside the United States. Now, there's also a little bit of a difference between sort of the executive and manager type and the specialized knowledge type also, in that the executive and manager, you can hold L1 status in the United States for up to 7 years. For the specialized knowledge capacity, it's only 5 years. And certainly there's ways to transition, whether it's your permanent resident status or other statuses, but there are these limits in L1 status in the United States. Another key aspect to this, especially in opening an office, is there's also a mechanism to transfer an individual to open an office, to start an office in the United States. It's slightly different criteria, and initially they're only given L1 status for a year. It can be extended, but it is also an option. We know, this employee would be great to start our office in the United States. They've been working at our company in France for 5 years, and sort of working in this sort of executive or managerial capacity. There is a mechanism to essentially transfer that person to start to start the U.S. office. Similar to the H-1B visa type, what we call this dual intent, so the ability to jump to permanent resident status a little bit more easily as well is there. And a key difference from H-1B is sort of the spouse. So spouses are work authorized as what we call an L2S, or the spouse of an L1 visa holder, and that is immediately upon entering the United States. It used to be you had to apply for what we call an employment authorization document, or an EAD, wait months and months, and then your spouse could get work authorization in the United States. But a recent rule change earlier this year now allows spouses of L1 visa holders to be work authorized immediately upon arriving in the United States as well. So a big key difference, and certainly in terms of quality of life and moving someone's family to the US makes a significant difference as well. So that's, again, the L1 is going to be a good way to get your talent into the US when they have that experience for your company abroad outside the United States. And then I think one other key or common visa type to bring up sort of in this context is the E2 visa type. So the E2s are what we call treaty investors. So there's sort of two sides to the E2 as well. It can be the actual investor in the United States, essentially putting up substantial capital in a US business, but it can be employees of sort of the treaty investor company that are working in a supervisory capacity or sort of considered an essential worker. And that might not be individuals that are making the investment themselves, but they are a foreign national with the same country of citizenship as the company itself. And those individuals are able to transfer to the United States. E2, again, is very country specific. So it's created through a series of treaties between the United States and foreign countries. So every country has its own treaty that serves as the basis for the E2 visa type. Certainly, it takes sort of a fact-specific look at where the company is based and ensuring that you're meeting all the requirements specific to that country. One common example I often give is the UK treaty requires that someone is domiciled or basically still living in the UK when they are moving or applying for E2 status in the United States. So I'll often see a UK company say, we have so-and-so, they're based in Australia, they've been there for 10 years, but they're a UK citizen, they meet the requirements of E2 visa type, right? And the answer is no, specific to that country, no, they don't have UK residency. They've been living in a different country for the last 10 years. So it does take, talking to attorney about what the specific requirements are based on the country where sort of the business and the investment is originating as well. And so the other good thing about E2s, very similar to the L1, is that spouses are also work authorized upon entering the United States in line with this new rule that just came out for L2 spouses. E2 spouses are sort of in the same boat as well. So it makes a big difference in terms of relocating families. The other difference, though, is what we call dual intent is not recognized. So there is a little bit of more of a dance that has to happen in terms of the ability to then move on to permanent resident status in the United States as well. Some extra steps that that individuals may have to go through if they're interested in pursuing permanent resident status. But essentially, E2 is going to require that individuals have the intent to return back to their home country at the conclusion of whether it's the investment or inclusion of their employment if they're working for the company that's making the investment. So just a quick sort of bullet points about some of the more common visa types that we see when businesses either are just getting into the US market and they're bringing their talent from outside the United States, or whether they're looking to hire individuals already in the United States and sort of use sort of already US based talent to hire when getting into US markets.
Thanks, Brian. That's really helpful info. Thanks for explaining that so clearly. I do see that we have a question from Joan. She's asking, I've heard that spouses have a language proficiency requirement that they need to meet before being granted a visa. Is that true? And generally speaking, that's not true. That is a requirement for student visas, but generally speaking, that's not a requirement for dependent visas. So if the individual is coming on a work visa and then their spouse is getting a dependent or spousal visa, for the most part, they're not going to have any English language requirements or tests or anything like that. And by the way, if anyone else has any questions, feel free to just type it into the chat feature, and we'll go through those as we go along the presentation. So Brian, one of the things that you mentioned right in the beginning was about the H-1B and about how we saw almost 500,000 applications this year, which is just completely unprecedented. And so I wanted to ask Danny, Brian walked us through the H, the L, and the E. We know that for a lot of people and a lot of companies, the E and the L just aren't viable options. If you don't qualify, if you don't have an entity abroad, you can't do the L. If you're not from that treaty country, you can't do the E. And so most companies default to the H, but now with what we saw this year, how are you advising your clients on alternatives to the H-1B moving forward?
Sure, thank you. So one of the alternatives is the O1 visa, and this is for individuals of extraordinary ability in sciences, education, arts, business, athletics, TV, movie, and there are specific criteria for the O1. So for science, education, business, and athletics, the individual has to demonstrate that they're one of a small percentage of people who have risen to the top of their field. But that field is based on a narrow definition of what their subject of expertise on. And so it may be a viable option. We typically see this with individuals who hold a PhD, who've had some publications, who help with peer review. And so to secure an O1 for science, education, business, or athletics, you need to either have a major prize award, something like the Nobel Prize, or more practically for most companies, meet 3 out of 8 of specific criteria. And those criteria can be awards in the field, membership in an association that requires outstanding achievement, major media coverage, work judging the work of others. And we see this most frequently when individuals conduct peer review for peer reviewed journals. And it can also be original contributions or publications or a critical role or even exceptionally high salary. So although the bar for O1s is high, it is achievable, especially for a lot of recent PhD graduates that may have publications, experience working with peer-reviewed journals, and a high citation count in their specific field of expertise. This also extends to the motion picture or TV industry. The criteria are set up in the same sort of format, but are slightly different. So if they have a major prize, that alone would qualify them, like an Academy Award or an Emmy or an Oscar. But also, if they meet the 3 out of 6 criteria, USCIS will accept that also to demonstrate their exceptional ability. And that could be that they are in a starring or leading role, that there are critical international reviews of them, they've had major commercial success or high salaries. So there is a variety of evidence that can be provided to demonstrate that an individual meets these criteria. And so if you do have employees that may be considered expert in their narrowly defined field, this may be a good option. For O1 individuals, the duration of stay that they're admitted is initially 3 years, but you can continue to extend an O1 for an individual to complete their event or activity. There also is an option for dependents to come over on O3 visa, although we'll speak later in more detail about the work authorization for dependents. Unfortunately, O3 dependents are not work authorized. In January, there were some updates for the O1 visa classification, and USCIS published in their policy memo how they interpret some of the criteria, and it's extremely helpful in getting a better sense of what they look for, and especially for the sciences. I think they went through giving some examples of the considerations, and many of the considerations they give are different criteria that many employees could meet, and they went through individually discussing the awards that would be acceptable, the type of media coverage, or the type of association memberships. So the O1 is a great alternative following the very low selection rate for this year's H-1B cap.
Yeah, thanks, Danny. And I think that last point is really critical in that for years, we kind of, the issue with the O1 is that the criteria and the selection process was a bit ambiguous. And with this policy manual update, I think at least what it does is it gives us more clarity on what is an O1 and what isn't an O1. And so it's really helpful guidance has really helped us being able to advise our clients and really open up that option of the O1, where in the past, maybe we didn't consider it as much as we do now. So definitely a big help, especially given what's gone on with H-1Bs this year. So let me go back to our questions, because Arthur just put in a question for Brian. Brian, you mentioned when you were talking about E2s that there is extra steps that you had to go through in order to jump from an E2 to green card or permanent residence. And Arthur was just asking if you could kind of explain what you meant by that.
Yeah, for sure. So the sort of treaties that serve the basis for E2 status may sort of provide some additional privileges or rights to E2 visa holders, and potentially as part of the permanent resident process applying for one's green card in the United States. The foreign national applicant has to waive or sort of give up some of those rights that may have been given to them as part of that in order to be able to go forward with the permanent resident process. So there can be sort of an ancillary application. It's called a Form I-508 that gets filed with the permanent resident application. There's also other considerations to take into account, including, there can be significant delays in the ability to travel going through the permanent resident process while holding E2 status. So a few sort of personal considerations as well. But there are, that's sort of the key additional potential step for E2 visa holders to jump to permanent resident status. And again, when entering the United States, holding E2 status, one should not be holding, the intent to be a permanent resident. Certainly that can come up later, potentially, but that's just one example of a potential additional step in the permanent resident process.
Yeah, so I think going from E2 to permanent residence is definitely possible, definitely something that we can help you out with and walk you through, but it's not as simple, it's not as straightforward as maybe going from an H or an L to a green card. And so just like Brian mentioned, some of those issues that do come up. So I think at this point, we've covered really the main work visa options. I want to change things up and have Brian talk to us a little bit about options for interns and trainees, which is becoming a little bit more popular and something that I think Brian can talk to us about using the J visa for these two categories of people.
Yeah, absolutely. So this is, the J1 visa type is meant to be an exchange visitor or sort of someone partaking in an exchange program. So, and I'm going, I think there's 14 subcategories of the J1 visa type and sort of exchange program visa type. I'm really just going to focus on trainees and interns because it tends to be sort of the most common that can be used by sort of multinational organizations and having people be trained or work as interns in the United States. And so, essentially J1s, again, it's an exchange program. So this is not going to be meant to be, long-term employment in the same sense that the H1B or the L1 or the E2 or the O1 are meant to be for individuals. So, the first thing, I'll talk a little bit about is, interns are going to be folks that either are enrolled in a university full-time outside the United States or recently graduated from a university within the last year. And essentially what happens is there's, there could be a host organization that is saying, we want to bring this intern to the United States as part of this exchange program and sort of allow them to get to know our organization or sort of maybe, rotate through different parts of our organization and they take part in this exchange program. Interns can be in J1 status up to 12 months. Similar but slightly different trainees are going to be, someone that is a little bit different. They're not enrolled in a university outside the United States, but they have, typically had at least 1 year experience outside after obtaining a degree outside the United States. It is a really good option for, essentially getting folks experience in the United States. But again, it's not going to be necessarily a long-term option. It's also, potentially a good way to sort of get to know candidates and sort of see how how they fare within the confines of being an intern or a trainee. J1s, because it's an exchange program, what we have is called the CVIS system, and this is the same system that it's used for F1 students as well. J1s, again, depending on the subcategory, the length of time one can hold J1 status is sort of dependent on the subcategory. Interns are 12 months, trainees are up to 18 months. You can change from J1 to other statuses in the United States, maybe, and depending on what that status you want to change to is. So the first thing we always want to talk about in the J1 context is the potential for what's called the 2-year residency requirement, or 212E. What this is, the J1 is an exchange program. And so the idea behind it, so the premise behind it can be this individual is coming to the United States, they're learning a skill, they're learning, something, and they're bringing it back to their home country. So the Department of State basically has a list of skills and a list of countries where if this individual is part of an exchange program, sort of to learn this skill, and if they're from certain countries that are listed on the Department of State list, individuals may have what we call a 2-year residency requirement, which means they should be returning back to their home country, their last country of residence, for at least 2 years before they can jump to certain other statuses, namely H-1B status, L-1 status, or permanent resident status in the United States. So important to keep in mind. There are other employment visa types out there that one might be able to change to, even if they do have this 2-year residency requirement. But if that individual ever does want to get H-1B, L-1 status, or permanent resident status in the United States, they're either going to have to complete that 2-year home residency requirement or request a waiver of that 2-year residency requirement. And that waiver can take, there's a few different options for applying for that waiver. The first is what we call sort of a no objection from your home government. Your home government says, no, it's okay. We don't need Brian, to come back to our home country. It's okay if he jumps to this status in the United States. We have no problem with it. There's other potential waivers, for medical professionals who are working in sort of underserved areas. And then there's certain waivers also, if essentially a U.S. government agency sort of supports the fact that they want to support the waiver. So there's a few different options there. But generally, there is the potential that this 2-year home residency requirement comes part and parcel with J1 visa holders, and certainly that should be kept in mind in terms of jumping into that visa type if interested in becoming a trainee or an intern, and certainly in sort of being a host organization for those as well. One thing we do just want to give a shout out, is FACCNE can assist hosting, professionals in sort of intern or trainee programs. And so, FACCNE does have this dedicated J1 team, and sort of Woodin can be the point of contact for any additional information that folks might want to reach out to her about as well. The links are there in terms of finding out more information on the FACCNE website, and emailing the folks at FACCNE as well. But they are an organization that can assist with this if it's something that your organization is interested in pursuing, or at least learning a little bit more about.
Perfect. Thanks, Brian. Next, I want to discuss a little bit about green cards, and specifically the options available for investors and entrepreneurs who are willing to make a sizable investment into a U.S. business. So Danny, could you walk us through the basics of the green card by investment option, which is more commonly known as EB-5, and some of the recent changes to the program?
Sure. So the EB-5 program allows for a permanent resident path for investors and their dependents. There are 2 main components that are the criteria. First is the investment. The minimum investment is a little over $1 million for standard EB-5 investments, and around $800,000 for targeted employment areas. A targeted employment area can be a rural area or an area with a high unemployment rate. And there is a specific portion of the EB-5 visa quota that goes to investments in rural areas and high unemployment areas and infrastructure projects. And then the other side of it is that the investor has to plan to create or preserve 10 full-time jobs for US qualified workers. And so there is a process with USCIS, and then the individual can either apply for an immigrant visa abroad, sorry, I went the wrong way here, or adjust their status. So there have been some recent updates to the program, and USCIS is going to resume processing of pending EB-5 regional center program cases. Also notably, starting in 2027 and every 5 years after that date, the minimum investment amount will be subject to increase, and it's going to be tied to the consumer price index. As I mentioned before, the quota is set up to align with different projects. And so 20% of the quota is going to go to investment in rural areas, 10% to high employment areas as designated by USCIS, and then 2% for qualifying infrastructure projects. You can also have a concurrent AOS filing. There's a priority for rural projects. And in this new update, there's going to be increased monitoring and enforcement of these regional centers around the country. And there are some additional EB-5 fees with some safeguards for investors. So one option to invest.
Perfect. Thanks, Danny. So the next noteworthy update that I'd like us all to discuss centers around family members and specifically spouses. So I know Brian had mentioned a little earlier that some of the rules have changed recently, and to me, it's gotten actually a bit confusing as to which categories allow spouses to work, which do not, and really what the process is to obtain work authorization. So Danny, could you walk us through the different visa categories that we've already mentioned, but kind of explain the rules surrounding work authorization opportunities for spouses?
Sure. So we'll talk today about work authorization for H4, L2, E2, J2, and O3 spouses. So to start, for the H4 spouses, and that's a spouse of an H1B holder, it is possible to secure work authorization if the H1B principal has met certain milestones of their immigrant visa process. So typically, the green card process for H1B holders is 3 steps. There's usually a labor market test, and then the second step is known as the I-140, or when your employer offers you a full-time permanent position. And so when you get to that second step of the green card process and you secure an approved I-140, that then allows a spouse of an H-1B visa holder in H-4 status to apply for an EAD card. With the recent updates, there are auto extensions now for EAD holders. So one of the big issues going on with USCIS that we're going to dive into more in this presentation are these backlogs that have been occurring. And this has certainly been a pain point for many spouses who came to the US. They secured work, they waited very long periods for an EAD card, and then when they would go to renew it, the timelines were extremely extensive, and very frequently the delays impacted their ability to continue to work. So USCIS has this new auto extension process for H4 holders who have a pending EAD renewal and a valid underlying I-94. Just for reference, the I-94 is issued when you enter the US and dictates the period that you're authorized to stay, and that's what's issued by Customs and Border Patrol and is available on their website for download. So the reason that also is important is for L2s, for example, with the recent policy changes, the spouses of L1s, they were always work authorized, but now there's a new process that they're work authorized incident to status, meaning you don't need that physical EAD card in hand to be work authorized. So when you enter and CBP issues your I-94 at the border, now they're issuing them with the designation L2S. And if you have that I-94 in hand that shows you're in L2S status, you're automatically work authorized. But because many people may have entered before this new process was in place, for I-9 purposes, it's also permissible to work with an unexpired I-94 noting you're in L2 status and a notice from USCIS with a new admission code. There are also auto extensions for EADs if you've had a timely filed renewal application and unexpired I-94. So same with E2s. So E2 spouses, their work authorized incident to status. So the EAD card itself is also no longer required for them. If they have this E2S designation when they enter the US on their I-94, or like the L2 category, they have the unexpired I-94 in E2 and a notice from USCIS. And there's also an auto extension option. For J2s, they're work authorized with an EAD and they need to evidence that the income is not going to be used to support the J1. And lastly, for O3s, this is not a work authorized category. So unfortunately, if a individual comes to the US on an O1 or changes to O1 status after studying in the US, their spouse is authorized to remain here, but they're not going to be work authorized. So that sometimes is a sticking point when employers consider visa options if they're interested in sponsoring an O1 for a candidate, but their spouse needs work authorization. So that can certainly be frustrating, but for the other visa categories, there is a lot of exciting developments going on to improve the processing times, or in the least to allow for those individuals to continue to work with a timely filed renewal or an I-94 with the designation that would allow them to work incident to status.
Danny, you just alluded to the growing backlogs that we keep seeing, and I really think this has become an especially critical issue over the last few months. So Brian, could you talk to us about the delays that we're seeing and what the outlook is for the rest of this year?
Yeah, absolutely. And I'll preface by saying, it's looking a little rough out there in terms of processing times, particularly with USCIS. So USCIS is sort of the immigration service in the United States that is adjudicating basically status petitions for employers or applications from spouses to maintain or hold status in the United States. So it might be that, you have an individual abroad who needs to go to the U.S. consulate, but USCIS in the U.S. might have to adjudicate something on the U.S. side first before you can even apply for a visa to come to the United States. Right now, USCIS has, this is information as of April, 8.5 million pending either petitions from employers or applications by individuals pending with them. And 5.2 million of those are beyond what they consider to be sort of regular or what had been normal processing times. So there is a significant backlog that has been amassed at USCIS over the last couple of years. Some of it's from COVID, staffing shortages. Some of it is from an increase in applications. And the other thing to sort of keep in mind is that USCIS is a fee-based organization. So they charge fees with each of sort of these applications that they accept, and that's sort of what basically keeps the lights on. So they have asked for some, say, a significant increase in appropriations from the U.S. government. It remains to be seen how that all shakes out. But essentially, we have very significant backlogs with USCIS. There are mechanisms to use what's called premium processing, or the premium processing service, that employers can use, when they're filing an H-1B petition or an L-1 petition or an E-2 or, the O-1. A lot of sort of the employment visa options that we've discussed to this point in our discussion can use premium processing, which gets an adjudication or at least movement usually within 15 calendar days. But what it doesn't help is other types of applications, whether it's applications for spouses to maintain status in the United States. Premium processing is not available for pretty much all of those applications. Work authorization applications, employment authorization document applications, seeing some significant backlogs, and also what we call adjustment of status, or your green card, permanent resident applications in the United States do not have premium processing available to them. So just looking at what USCIS considers normal processing times as of this morning, for individuals in Massachusetts, an employment-based green card application, they consider normal processing time right now 15 months. It used to be, 6 to 9 months, not too long ago. For employment authorization documents, based on submitting your permanent resident application, or for spouses to get work authorization for certain visa categories, 8 to 20 months, depending on where the application ends up with USCIS. So it's a pretty bleak outlook right now in terms of processing times. Yes, there's ways to submit what we call an expedite request at USCIS and say, hey, please approve these things faster for me. But there's no good system for that. It's fairly archaic, and it is fairly, it's not often that USCIS agrees to expedite anything. So one thing to keep in mind, especially when it comes to sort of spouses and the permanent resident process, is it's going to take a long time based on current processing times with USCIS. USCIS has announced that they are going to expand premium processing beyond what sort of the classifications that exist for right now, but it's going to be a slow rollout. So right now, they are going to be rolling it out this year for what we call multinational manager. I-140 is basically a certain step in the permanent resident process, but sort of in parallel to L1A, multinational manager visa holders. That didn't used to exist. They are rolling it out for applications for spouses, L1 spouses called L2, E2 spouses, H4 spouses of H1B visa holders, to eventually have premium processing both for their personal applications to maintain status and potentially for their work authorization documents as well. But that's expected to be rolled out in fiscal year 2025. We're in fiscal year 2022 right now. So I think fiscal year 2025 starts October 1st, 2024. So we're 2.5 years from that rolling out if they keep their schedule, which remains to be seen. So, unfortunately, it's sort of the reality of the environment that we have right now with the U.S. immigration system. It's important to understand that, and sort of important to understand the timelines that folks might be up against. And certainly USCIS is trying to take actions to clear out this backlog, but it's sort of an uphill battle for them. One thing will sort of throw everyone a little bit of a bone is they have increased what we call sort of an automatic extension of work authorization for certain select individuals. Doesn't help everybody, but it helps some folks. It used to be that if you have sort of a work authorization renewal in certain categories pending with USCIS, you automatically get work authorization extended 180 days. They have upped that now, and I think it's sort of them conceding how backlogged they are. They've upped the automatic extension of a work authorization document to 540 days, so significantly longer time period as well. It doesn't help everybody. It sort of only helps a select few sort of work authorization applicant types, but it is something that does help some individuals as well. So that's what we're looking at right now, both for backlogs and for getting through those backlogs and what to expect when working with USCIS and submitting these petitions or applications.
Thanks, Brian. And I actually had an interesting question from a client the other day who said, it's great that they're expanding premium processing, but what's this going to do to the non-premium processing cases? Does that mean that this, standard 15-month processing time is now going to all of a sudden be 20 months? Or, and I know you don't have necessarily the answer. I don't know that immigration does, but any thoughts to that? Because I thought that was an interesting question.
Yeah, it's a great question. So if looking at from sort of the ideal perspective, premium processing costs money. It costs a good amount of money. It's going to vary depending on the type, but just generally $2,500 to use premium processing for most petitions that get submitted to USCIS. And in the ideal world, they would use those funds to sort of bulk up their premium processing service. And it's a sort of different unit that is going to adjudicate things more quickly, and ideally bulk up staffing and sort of the regular processing, and it wouldn't create more of a delay on the regular processing side. But like you said, Aaron, we just don't know. It sort of remains to be seen how they go at this backlog and sort of how they reallocate resources. If sort of anecdotal history and personal experience is anything from my perspective as an immigration attorney for the last decade, we could easily see regular processing be backlogged even more and sort of say, okay, that's fine. You guys go to the back of the line and we'll get to you when we get there.
Exactly. And unfortunately, the delays that you're talking about in the US with USCIS, we're also seeing those abroad at US embassies and consulates throughout the world. And so, Danny, could you talk to us about what you're seeing at some of the more commonly utilized consulates that our clients are going to?
Sure. So across the world, since COVID has started, there have been tremendous backlogs at the consulates. Some of that is due to staffing and the closures and the state of the situation on the ground. So what we've seen, especially in the COVID climate, is that the appointment availability can change very rapidly and can certainly, there can be cancellations of appointments or no appointment availability very quickly as a COVID situation in a specific country may escalate and the consular staff is impacted. But that said, the situation does appear to be improving. The consulates have reopened and many are accepting emergency appointments. The bar remains very high, but they will review those materials. To speak to 3 consulates, specifically Paris, London, and Brussels. Paris, there are no consistent openings right now, but there is sporadic availability. But the team is responsive to true emergencies and does attempt to help with any issues. In London, there seem to be spring and summer openings based on the visa classification, but there's they're prioritizing F and J visas, but there is sporadic availability for other visa classifications. What our consular team is finding is that the appointment availability depends on the family size, but they did mention that there may be better luck in Belfast if you are in the UK. And then Brussels seems to be on a more consistent schedule for Belgians, residents, and work permit holders. There is availability starting in June for third country nationals using the post for visa processing. The availability is more limited and appointments start in October. So typically in these situations, we recommend securing the visa appointments that are available and looking for openings. The situation certainly is improving as they work through these tremendous backlogs that have built up over the last 2.5 years, and we would expect it to get better. But right now it remains a fluid situation.
Thanks, Danny. So I think at this point we can go turn our attention to some of the questions. I see we have a few right now, and if anyone has any other questions, now would be a great time to type it into the chat box. So to start off, first question is, children that are on an L2 visa where their parent is on an L1A, what happens if they're over 21 years old and their green card has not yet been approved?
Yeah, I can take that one. So this is a little bit of a fact-specific inquiry itself, but there is something called the Child Status Protection Act, CSPA for short, that essentially legally locks in a dependent child's age at certain points in the permanent resident process, to the point where, for example, if their adjustment of status or their green card application is pending at age 19 and is just pending through sort of the fault of USCIS and these significant backlogs, but they've otherwise been eligible the whole time to be approved, they're sort of locked into being 19 years old or whatever their age might be. There's a little bit of arithmetic that goes into this. There's other factors that go into this, including the principal green card applicant, so the parent applicant's country of birth, and whether or not they're from a country that's backlogged for permanent resident status in the specific category that they're applying in. So the short answer is it depends, but there is sort of a mechanism. There's a rule in place that helps protect individuals from what's called aging out, or still being able to have their green card approved, if they've reached a certain stage in the process prior to turning 21. Certainly, if we don't even get to those stages, and a 21-year-old child reaches that age, then they wouldn't be eligible for the green card process. They wouldn't be eligible to hold L2 child status. So just sort of a quick overview. They could be okay depending on where things are and sort of the timing and their age.
Thanks, Brian. And this person didn't ask it, but let's just say hypothetically there is no green card in process and that's not a consideration. What do you normally advise parents that have children on like an H4 or an L2 and are approaching their 21st birthday?
Yeah, it certainly can be a challenging conversation. Essentially, it's sort of going through a lot of what we've talked about also in sort of this conversation, this presentation today. Very often that child might be at a U.S. university. Can they move to F1 student status and then sort of jump from there into their own, holding their own sort of employment-based immigration status in the United States? It sort of takes into consideration and talking about sort of what the goals are for that 20-year-old child and what they're trying to accomplish as well. The unfortunate aspect is, if we don't have other things already in motion, that individual will not be able to hold that status, beyond that age. But it sort of takes a sometimes tough conversation, sometimes frustrating conversation, but one nonetheless, to see what other options might exist for what is now, a grown adult, and being able to stay in the United States, if we're not to that point in the permanent resident process that they're protected by the existing rules.
Thanks, Brian. And I probably should have mentioned to everyone just the basic fact that children can get these dependent visas, but once you turn 21, you're no longer considered a child for immigration purposes, and then you would really be on your own. And so just to add some context to that question. The next one I think is a good question for Danny. We have a question about EB5. So I was approached with a request to identify a growing solar company for which 3 individual international investors would invest $1 million each, so $3 million total. The intent was to recoup their investment in approximately 3 years through the success of the solar company. Is this something that's possible? Is this legal? Is this something you can do under EB5?
Sure. So the EB5 criteria, you have to meet that minimum investment, each individual for the EB5. If it's not in one of those, I can switch back to the slide here, pull up the, if it's not one in, here we go. So if it's not in a TEA, a targeted employment area, it would need to be a little over $1 million and have a plan to create 10 full-time jobs. If it is in that TEA area, then the investment only has to be about $800,000 with this plan to create 10 full-time jobs. And so I think we would have to take a closer look at the intent of each of the investors and check out the specific facts for this case, but the general requirements for each individual would be this type of investment.
Thanks, Danny. The other thing I would add is that to be able to make the investment and then recoup or get your investment back in approximately 3 years is frankly not feasible for an EB5 for the time frame we're looking at. And how long you have to have your money invested, it varies, but in most cases that I've handled, you're looking at least 4 or 5 years, if not longer. So if the person with that question, feel free to reach out to us if you want to discuss further, because definitely a very fact-specific situation there. Okay, and then the last question for now, I think this is a good one for Brian. Can you try the green card lottery while under an E2 or change your status to H1B?
Yeah, sure. So I'll answer the second part first. You can change your status to H1B, and that's sort of a non-issue. That's feasible. You do have to enter sort of the, assuming you're working for sort of a private employer, enter that H1B cap lottery each March as well. But that is feasible. In terms of being able to go forward with the green card process or permanent resident process, it is feasible while holding E2 status. Again, typically I always recommend having a conversation with an immigration attorney, because there are sort of those extra factors that I talked about a little bit earlier. But it is feasible, it is possible to go forward with the permanent resident process while holding E2 status in the United States. And you can change to H1B status that's no problem. The one thing I will say about, sort of E2 versus H1B is, H1B status is limited to 6 years in the United States. E2 status you can hold in 2-year increments and can keep extending that or sort of push that along for as long as you wanted to, so long as, your job meets the requirements, your role and skill meet the requirements depending on the E2 sort of category that you're falling under. So the short answer to both those questions is yes and yes.
Great, thanks, Brian. And it looks like that is the last question, and we're just about out of time. So I'd like to thank everyone for attending today. I'd like to really thank FACCNE for hosting and for having us here. If anybody has any questions at all, you see our contact information up on the screen. Feel free to reach out to us. You can reach out to FACCNE if you need to inquire about a J1 as we described. And otherwise, thanks everyone for attending. It was a pleasure speaking to you.
Thank you, everyone.
Thanks, everyone.
Thank you, FACCNE.